Ladies and gentlemen, this is our final sports law seminar and sports law workshop, which is organized, I mentioned earlier, by the Sports Law Academy in Vancouver, Canada, and especially organized by the Maharashtra National Law University in Mumbai, which is a leading law school in India. Now, sports law, we divide it into 5 sections: disciplinary cases, disciplinary rules and regulations, and what is the process to discipline an athlete or a sports federations. And I will touch on the latest anti-doping rules 2021, which were introduced by IAAF, now known as World Athletics. The World Athletics event just concluded in Oregon a few days ago. And lastly, as sports lawyer, you will render legal advice. So these are the 5 items governing sports law. And remember this, sports law is not common law. Sports law is not civil law. It's a fusion of both common and civil law. Fusion. Diego, next please. And this is from my guru, Professor Michael Beloff. That's what he has to say about disciplinary cases in sports law, in sports, governing an athlete or a national sport federation. As I mentioned earlier, English courts or national courts in any jurisdiction, common law or civil law, are reluctant to intervene in sporting dispute unless there is a clear case of unfair or unlawful operations in the domestic machinery for resolutions of sporting disputes. Now, in sports law, there's no need for a sportsman to enter into a contract to be governed by the disciplinary tribunal. Participation in a particular sport is more than sufficient. Participation amounts to a willingness to be governed by the regulations of that particular sports federation. Next, please. As I mentioned earlier, there is minimum interference by national courts. National courts in any common law country, I use common law first, right? Always consider sporting issues, sporting cases as best adjudicated, and they are reluctant to intervene in the internal regulatory affairs of sports governing bodies. And I have a copy of this book, which is about 1,500 pages. Now, the only exception is when there is an element of criminality. When there's an element of criminality, I take this opportunity to welcome my law students from India. India, as you know, is a great sporting nation. They are extremely good in field hockey, extremely good in cricket. Next, please. We must always know that any adjudication, ultimate punishment, has to be current, has to be subjected to the latest regulations. Now, there is a basic principle. No punishment for the offense if the governing rules and regulations do not even provide for such punishment. Like, for example, if there is no automatic suspension, then you cannot impose it. And it very important is the conduct or the offense must not be contrary, must not be inconsistent with the rules and regulations existing at the time of the alleged offense. There is a case law on that. Any change in the rules and regulations must immediately be brought to the attention of the players involved. This is, in other words, subjected to the rules and regulations of natural justice. Next, please. Adoptions of new rules. Now, disciplinary regulations of any sports federations at national level must be consistent with its constitutions. That is constitutionally correct. Now, they will have to draft rules and regulations to deal with disciplinary measures for misconduct and resolutions of dispute arising from misconduct, like fighting on the sports pitch. And if there is any amendment, it must be brought to the immediate attentions of its members and posted on the website of the national or international governing body, together with notifications using the newsletters, their emails, and right now, especially in many countries, perhaps on social media as well. One thing, the rules and contracts must ensure compliance with the rules amended periodically. In other words, rules are subjected to revisions, whether it is World Athletics or soccer, etc., etc. Next, please. As I say, the disciplinary process of national governing bodies, they are very important. National courts, be it civil, be it common law, do not interfere. International governing rules require national bodies to have their own sets to deal with the particular game. Now, in the, like Ms. Chang has mentioned, the Asian Games have something like about 40 games. One sports like cricket, but in the Olympic or in the Asian Games or the Commonwealth Games, there are many games, and each game may be subjected to its own national or international sports federation. Now, disputes within the sports can only be educated and settled internally by its own disciplinary process. There must be a right of counsel, right to fair hearing. Now, international federations can be, the rules and regulations can be amended and can be varied by the national bodies. In rugby, for example, disciplinary process is governed by the International Rugby Board regulation, and all national bodies must follow. Now, rugby, as you know, is a very important game in New Zealand. Rugby is a very important game in countries like England and Europe. And I've just learned from my assistant professor, Diego, that rugby is not very popular in Brazil. Is that right, Diego?
Yes, Professor. You know that our main sport there is soccer, right? So there's not much space for rugby.
Yes. It's very important in New Zealand, the All Blacks. Next, please. Now, what are the major grounds for internal disciplinary proceeding by the national governing bodies. There must be, and this is clear-cut, prohibitions of unethical issues such as doping, misconduct on or off the field, and corruptions such as match fixing. Then grants of licenses to individuals, to entity, there could be revocations, there could be restriction. These are the major grounds for internal disciplinary proceeding. And like in the last Winter Olympics, the famous national figure skater from a particular country was given full protection. A child is given protective rights, or anyone under the age of, I believe, 16. Now, jurisdiction or authority over eligibility process. In other words, the selection must be fair, there must be level playing field, the conditions must be clearly spelled out for international competitions. There must not be corruptions or unfair treatment just because he or she is a child of a sports official. And the other things we talk about will be promotion and relegations of members' clubs. So all these areas are major grounds for internal disciplinary proceedings by national governing bodies, be it cricket, soccer, rugby, ice hockey, etc., etc. Next, please. Now, the questions. Please ask me all questions after the end of the seminar, where I will be supervising a questions and answer session. We'll leave all questions. Why do we need to have independent disciplinary tribunal? The emphasis says the word independent. Why independent? Well, members of the tribunal must not be parties who apply for the disciplinary tribunal to be set up. That is obvious. Make sure that there is no unfair treatment. Justice must be done. There will be independent. Such external bodies, whether it's national or international, can always take the case up to the UK sports resolutions, or at the international level, the Court of Arbitration for Sport, or CAS. Now, an independent body appointed by sports governing body in UK is also qualified as an arbitral institution, and its decisions are capable of review by the English Arbitration Act of 1996. But the important thing will be the National Sports Arbitral Body. Like UK, you have the Sports Resolution. On a global level, you have the CAS, which is based in Lausanne, Switzerland. Next, please. Ad hoc implied contract. As I mentioned earlier, there's no need for a sports person to enter into a contract in order to be subjected to the jurisdiction of the national body. Participation is good enough, right? One of the party is likely to have a formal contract, usually a member of a club or governing body, which is a member of the disciplinary body. But the individual members, the athletes, do not need to have a formal written contract. And this is based on an English case, an athletics case. Participations amounts to a contractual arrangement. Next, please. Now, why is disciplinary tribunal different from a court of law? As I mentioned before, disciplinary bodies are not national courts of law and are not required to function like any courts of law, be it in Singapore or in India or in anywhere in Europe. And they are not bound, remember this word, not bound by the strict rules of procedure and evidence. That is why, right from the beginning, I did mention that hearsay evidence is admissible in sports law proceeding. Hearsay evidence. You must not misinterpret the meaning of the rules that they are applying. And it must always be the principle of fairness, justice, and equal playing field. The principles of fairness, justice are important issues in the adjudications of a sports law dispute. Next, please. Now we talk about legal advice in disciplinary proceedings. Oh, just to let you know, ladies and gentlemen, if you hear any sounds, they are sound of the Canadian wild geese or Canadian seagulls, okay? I have to open my window because of the heat, because right now we are subjected to a severe heat wave, even in Vancouver at 36 degrees centigrade. So I have to open the window, and the only noise that you can hear from will be from the wild birds. Now, legal advice, we give legal advice all the times in disciplinary proceeding. Like the doping code of WADA, players must be responsible, they must know their contents. Legal advice can be given if there is any breach. Legal advice must be given. When will legal advice be useful? One, in drafting some rules and regulation, and they have to be simple and easy to understand. Simple and easy to understand. Next, they have to arrange for disciplinary procedure, whether it is in soccer or in cricket. And the conduct of the disciplinary tribunal is very important. There must be one thing, fairness, right of representations, if possible, by counsel. You can always challenge the decisions of the tribunal. How? By appealing its decisions to the court arbitration for sports in. Now, Michael Peloff on sports law, and you have a copy of his book because I have donated 2 copies to the university in your university, Maharashtra National Law University Library. You can find a copy there, and copies are found in most libraries, be it Singapore, Hong Kong, Japan, etc. Now, but Michael Beloff said, and he is a leading class arbitrator, achieving good decision on making the conduct of disciplinary proceeding is to appoint, he is helping me, to appoint a lawyer to chair the disciplinary panel. Not necessary, but he did say it is a good foundation. It is not necessary, although Michael, my good friend from Trinity College in Oxford University, mentioned that it is a good decision. Next, please. unnatural justice or unlawful conduct of disciplinary tribunal. That's very important. I won't use the word accused. I will use the word offender, because this is not a court of law. Has to be given a fair hearing. Otherwise, there is no natural justice or legal fairness. Must always remember, a member of the tribunal must have no financial interest or in the outcome of the hearing. You have to ensure that the member of the tribunal is not related to the offender. I will use the word offender rather than accused, because this is not a criminal court of justice. Okay? Now, for example, imposing a sanction or penalty higher the range of sanction. For example, fining an athlete 10,000, where the rules and regulations of the national body provide only for a provisions of 5,000. This is an increase of 100%. If that is the case, it is definitely not fair, and there's no administrations of natural justice. Next, please. Now, this is a famous case, the tennis star, and he was banned for life. And I agree with the decision. Why? Because the International Tennis Federations banned him for life and also fined him 100,000 for attempting to determine the outcome of an event. Now, soliciting or facilitating a player not to use the best efforts in winning or losing the game. Because here, the money is involved, benefit is involved, and considerations to another to cover. However, in this case here, the tennis star make an appeal to CAS, the Court Arbitration for Sports. His life sentence, life suspension from the game of tennis was upheld by CAS, but the fine of 100,000 was squashed. I believe in the decisions, and I believe that is a correct decision. Next, please. Now, minors and penalties, and this I've already covered in my opening remarks. Now, the issue here, would a minor be bound as a tribunal lacked jurisdiction over her when she was tested positive for a prohibited drug? In this case here, the tribunal in International Federation, I think Tennis Federation, said that they will be governed by the law of contract. Now, in the English law of contract, or the common law of contract, right, it is, you cannot enforce a contractual right against a minor. However, there is an exception if it is to the career or the future benefit of that particular minor. Now, in this case here, rightly, the player has actually benefited from the contract. This would enable her to establish and to achieve fame, fortune, her future, her employment. These are substantial benefits in the English law of contract or common law of contract, where a contractual right can be upheld against a minor. 15, please. Now we come to the Olympic Charter and the World Anti-Doping Code. The Olympic Charter has this spelled out clearly. Any athlete or national sportsperson can be banned for more than 6 months for a doping offense from taking part in the next Olympics was void and unenforceable. In other words, if the athlete has already been punished, and also to prevent the athlete from taking part in the next Olympic, that would be null and void. Now, this is part of Swiss national law. Just to let you know, because most of the sports organizations are based in Switzerland and they are governed by default the Swiss national law of association, Swiss national law of association. Next, please. Now, here I will talk about swimmers from PRC. Now, this case here, 2 PRC swimmers were tested for a prohibited drug, and they appealed to CAS against a 2-year ban imposed by FINA. FINA is the World Federation for Swimming. However, in their pleading, they say they did take a health food, and that had been responsible for a prohibited ingredients. Rightly, the burden of proof is the player definitely must show how the prohibited substance enters his body or her body. That is the burden of proof. Next, please. Now we must talk about different disciplinary proceeding for the same sport. For the same sport, whether it's cricket or in soccer. Now, in England, it is dealt by the Football Association or FA. But some aspects of it may be under the jurisdiction of the FA League or Football League. Now then, misconduct or breach of the soccer rules and regulations, especially fighting on the soccer pitch, is dealt by the FA of England. Then breach of the rules of the league can be dealt by the particular league, whether it is UEFA, that will be under the Europa League. Now, FIFA and UEFA have jurisdictions to deal with their own breaches, right? FIFA is the international body for football, and UEFA is the well-known soccer league in Europe. Next, please. Now, I will talk about CAS, which is the Court of Arbitration for Sports, which is based in Lausanne. And in fact, the rules of most of the international sports federations, they do provide in their constitution for appeals against their own tribunal decisions to CAS, which is the Court of Arbitrations for arbitrations based in Lausanne. And CAS has jurisdiction within its rules and bylaws to deal, or when both parties voluntarily submit to its jurisdiction, whether it is the national athlete and the National Sport Federation. CAS has these jurisdictions. Next, please. I will touch briefly on the anti-doping rules 2021 issued and drafted by World Athletics, formerly known as IAAF. It is very independent and have no references to legislations of any national governments. It is independent. And the rules and regulations run into more than 100 pages. And its formulations of the rules and regulations are given to a body within IAAF, and that is known as the Integrity Unit. Then all violations are there of the rules and regulations, especially this anti-doping rules 2021, are adjudicated and heard before the disciplinary committee of World Athletics, which is the new name for IAAF. And they are applicable, do not remember this, to all national athletics federations, international level athletes, and their support groups and competitors. Support groups and competitors. Next, please. Now, duties of the athletes and the support personnel and member federations. 1, they must be knowledgeable. They must comply with the 2021 anti-doping rules. There must be clear understanding of the anti-doping violations, substances, and the methods included in the prohibited list. Most importantly, it must be available for sample collection, be it urine sample or blood sample. And there must be research into products or substances. This is a responsibility of the national athletic bodies, that there are no violations of the 2021 rules. Now, medical treatment dispensed to the injured athlete must not be violations of the rules. Cooperation in any anti-rule violations is also an offense. Next, please. Now, there are many anti-doping violations under these 2021 rules. Present, number 1, presence of a prohibited substance in an athlete's sample, usually a urine sample. It is not necessary to establish fault, negligence, or knowledge on the part of the athlete. Remember this, not necessary to establish fault, negligence, or knowledge on the part of the athlete. Whether it's successful or not is immaterial. Any attempted use of a prohibited substance or method amounts to an anti-doping violation. Does not have to be successful. Evading, refusing, or failing to submit to sample collection. Evading. When you are asked to supply your urine sample, and you must give your known whereabouts. In fact, possession is good enough. Possession of a prohibited substance or method is an anti-doping violation. It doesn't have to be dispensed. By bringing and you're caught with possession, it is a violation. 22, please. Now, there can be indirect anti-doping violations. Now, trafficking or attempted trafficking of any prohibited substance or method. Trafficking. You try to make use of the prohibited substance. Or you can be an offender if you give it to another athlete unknowingly or knowingly in competitions of any prohibited substance or method. Then complicity or attempted complicity is also a violation. This is very clear cut. Complicity. And then, if you do anything to discourage the offender or the support group from reporting, you do anything to discourage reporting or admission, that is also a very serious anti-doping violation. My last slide, Diego. It is very important as sports lawyer or sports medical staff to understand the proof of doping. Now, the burden is up to the, as I mentioned before, the integrity unit of World Athletics or any anti-doping body at national or international level. Now, again, unique to sports law. What is the standard of proof? For common law student, criminal law, we always know, is beyond a reasonable doubt. And for civil matters, it's based on a balance of probabilities. So the standard of proof is between these two balances, probabilities and beyond reasonable doubt. Then there are analytical methods in approved laboratories by WADA. WADA is the World Anti-Doping Agency. WADA is the body used by sports organizers, sports events ranging from the Olympics to the common law games or even to the Asian Games. Now, there must be compliance with international standards. International standard in WADA accredited laboratory has to be accredited. Like the last Olympics in Rio, right? WADA has accredited laboratories. In Brazil, with this, I am very happy to say that this is the conclusions of my PPT, and